So, imagine you're playing a game, right? Like a highly competitive soccer match or something.
Oh, I love sports analogies. Go ahead.
Yeah, so you score the winning goal, the crowd goes absolutely wild, you're celebrating with your team, you have that sheer rush of victory.
Best feeling in the world.
Exactly. But then the referee blows the whistle, walks right onto the field and says, actually, based on my assessment of your footwork leading up to the goal, that doesn't count. And in fact, by my authority, the other team wins.
Wow. I mean, that shatters the entire illusion of the game.
Right.
You'd
Yeah.
immediately question why you even played the match if the person in charge could just, unilaterally override the players on the field like that.
It sounds like madness. It sounds like a totally rigged system.
Mhm.
But in the American legal system, the judge, who is basically the ultimate referee, has the power to do exactly that.
They really do.
A judge can look at a jury's hard-fought verdict after weeks of a trial and essentially say, no, that's not going to happen. I'm tossing out your decision.
Which is wild to think about.
It is. So welcome to today's deep dive. We are jumping into a massive, highly technical area of law today, which is federal civil trial procedures and post-judgment motions.
It's a big one.
Yeah, and our mission today is to take this dense rule book and, well, translate it into simple English, because if you are learning these concepts in a second language, or if you're gearing up for the multi-state bar examination, the MBE, this material can feel like a labyrinth that's like designed specifically to trick you.
Oh, the examiners absolutely use this area to set traps. I mean, they prey on the tension between that sacred democratic right to a jury trial and the incredibly strict, almost unforgiving limits placed on how you actually exercise that right. We're dealing with the entire life cycle of a federal civil trial here, getting in the door, selecting the human beings who will decide your fate, the actual presentation of evidence.
It's
And then,
surviving the post-trial phase.
yes, exactly, where lawyers file these desperate motions to either protect their victory or completely overturn their defeat.
Okay, let's unpack this. We're going to walk through this chronologically, and we'll pause to recap often so it really sticks. So let's just skip the table of contents and walk right up to the courthouse doors.
Sounds good.
You have a dispute. You want to sue someone. Naturally, you assume you get a jury, right? I mean, we all watch the same movies. There's always a jury.
There's always dramatic music in a jury box, yeah.
Right. But the reality of the Seventh Amendment to the U.S. Constitution is much more restrictive. Rule 38 of the Federal Rules of Civil Procedure preserves the right to a jury, but the Seventh Amendment only guarantees it for what the legal system calls actions at law.
Yeah, and the terminology here is, well, it's a historical artifact.
Okay, break that down for us. What does that mean in simple English?
Sure. To understand actions at law, you have to look back centuries to the English court system. They essentially had two separate systems running parallel to each other.
Like two different buildings.
Basically, yeah. There were the courts of law, which dealt in strict monetary compensation. So if someone breached a contract or broke your wagon, the court of law would calculate the damage and order the defendant to pay you money. That is an action at law.
Money equals law.
Got it.
And the other system.
The other system was the court of equity. Equity was administered by the chancellor on behalf of the king. And equity stepped in when just handing over money was not going to fix the problem.
Give me an example of that.
Okay, if someone was polluting the river that flowed onto your property, paying you a few coins wouldn't stop the pollution, right? You needed a court order forcing the person to physically stop doing the bad thing.
Ah, an injunction.
Exactly, an injunction. Equity is about fairness, action, and prevention, not just writing a check.
Okay, let's bring that into a modern context to make it super clear for everyone listening.
Yeah.
Let's say I'm suing my neighbor. They have this massive, ugly, rotting oak tree.
A classic law school hypothetical.
Right. So a huge branch snaps off, crushes my brand new roof, and causes $10,000 in damage. I want that $10,000 from my neighbor because I'm asking for money damages to compensate for a past harm. I am bringing an action at law. Therefore, the Seventh Amendment guarantees me a jury, right?
Yes, exactly. The jury will sit there, listen to the arborists, look at the photos of your smashed roof, and decide if the neighbor was negligent and owes you that $10,000.
Okay, but let's twist the scenario. Let's say the branch hasn't fallen yet. It's just looming ominously over my house, visibly rotting.
Scary.
Super scary. So I sue my neighbor, asking the court for an injunction to force them to cut the tree down before it crushes my roof.
Right, so in that case, you were not asking for money. You were asking the court to compel an action. This is an action in equity.
And in that equity scenario, I don't get a jury.
Nope.
I'm just standing alone in front of a judge, and the judge makes the call completely solo.
That's right. The judge acts as both the referee and the fact finder.
Okay, but what happens when real life gets messy and the scenarios combine? What if the first branch already fell and destroyed the roof, so I want the $10,000?
But the rest of the tree is still there.
Exactly. The rotting tree is still standing there, so I also want an injunction forcing them to cut down the rest of it. I have an action at law and an action in equity in the exact same lawsuit.
This is where we run into a landmark Supreme Court case. Beacon Theaters, Inc. v. Westover.
Okay, Beacon Theaters, what happened there?
Well, the court had to untangle a really tricky procedural knot. You have one judge and one jury in the room. They both have jobs to do, right? But who gets to go first?
Who gets to decide their part first?
Exactly. The Supreme Court ruled that when a case involves both legal and equitable claims that share common factual issues, the jury must decide the legal claims first.
The jury goes first. Let's press on the logic there. Why does the jury get the right of way?
It's entirely about protecting the constitutional right to a jury trial. Let's imagine the reverse for a second. Let's imagine the judge decides to tackle the equitable claim, the injunction about cutting down the tree first.
Okay.
The judge listens to all the testimony and has to decide, is this tree actually dangerous? If the judge rules, no, I find that this tree is perfectly healthy, so I'm denying the injunction, well, the judge has just made a definitive factual finding about the state of the tree.
Ah, I see the trap. So now the court turns to the jury to decide the money damages for the broken roof. The jury is supposed to decide if the neighbor was negligent for keeping a dangerous tree, but they can't.
They can't.
The judge already officially declared the tree was healthy.
Exactly. The jury is functionally locked out.
Mm-hmm.
The judge, by going first, preempted the jury's fact-finding role. The jury basically just becomes a rubber stamp.
Wow.
Yeah, so to prevent the judge from accidentally or, intentionally stealing the jury's constitutional power, the Supreme Court mandated that the jury goes first.
Okay, so the jury determines the facts related to the money damages.
Right. And once the jury speaks, the judge is bound by those factual findings when deciding whether to grant the equitable injunction.
I love that. Okay, if you're building a mental framework for the bar exam, or just trying to remember this in simple English, think of a formal dinner.
Oh, I like where this is going.
Yeah, think of a dinner where the host enforces a bizarrely strict rule. You must finish your main course before you are allowed to even look at the dessert menu.
Mm-hmm.
The legal claim, the money damages, is the main course. The equitable claim, the injunction, is dessert.
That's a great way to picture it.
Right. The jury acts as the chef for the main course. The judge has to sit patiently, eat whatever the jury cooks up, and accept those flavors before they are allowed to move on to prepare the dessert. You cannot skip straight to equity.
The sequence is ironclad, legal before equitable.
Let's do a quick recap for our ESL listeners and anyone taking notes. Legal equals money, which equals jury first. Equity equals injunction, which equals judge second.
Perfect summary. But now, just because the Constitution guarantees you that main course doesn't mean the court is going to automatically serve it to you.
You have to order it.
Yes. You have to order it. Federal Rule of Civil Procedure 38B lays out the mechanism for demanding a jury, and honestly, it's a procedural minefield.
Okay, what are the rules for demanding it?
Well, first, the demand has to be in writing. You cannot just stand up at a preliminary hearing and tell the judge you want a jury.
No verbal demands. Got it.
And the clock is incredibly tight. You must serve this written demand on the other parties within 14 days after the last pleading directed to the issue was served.
Okay, so 14 days. And a pleading usually means the complaint or the answer, right?
Right. So the defendant files their answer to your lawsuit. Boom, the clock starts ticking. You have exactly 14 days.
But wait, what if a lawyer just forgets? Like they get busy, their calendar system glitches, and they file the written demand on day 15. The other side hasn't been prejudiced. It's only one day late. Surely the court grants a little grace for a fundamental constitutional right.
You would think so, but no. The federal rules are merciless on this point. If you miss that 14-day window, you waive your right entirely.
Entirely over one day.
Entirely. It's a strict use-it-or-lose-it regime. The system defaults to a bench trial, meaning the judge decides everything. Unless you affirmatively raise your hand in writing, the courts view the waiver as absolute.
Okay, MBE test takers, highlight this. This is a classic trap.
Oh, absolutely. The examiners will craft a fact pattern where a highly sympathetic plaintiff verbally begs for a jury on day 16. And the correct multiple choice answer is always that the right is gone.
Use it or lose it. 14 days. Okay, so we follow the money to get the jury. Legal goes before equity, and we demand it in writing within 14 days. Once we navigate all of that, how many people actually show up to sit in the jury box?
Well, state courts often have 12 jurors plus a handful of alternates sitting in the back row taking notes, just in case someone catches the flu.
Right. That's what we usually see on TV.
But the federal civil system operates differently. Under Rule 48, a jury must begin with at least 6 members and no more than 12.
Okay, 6 to 12.
Yeah. The exact number is usually up to the judge's discretion. But the real shock for practitioners moving from state to federal court is that there are no ultimate jurors.
Wait, really?
None.
None. Zero.
But if a trial is scheduled to last a month, the odds of someone having a medical emergency or a family crisis are incredibly high.
They are high. But the federal rules change to eliminate alternates. The philosophy is that every citizen who sits through the trial should participate in the verdict.
I guess that makes sense. It would stink to sit there for a month and then get sent home.
Exactly. The old system of having 2 people sit through weeks of testimony, only to be told at the very end, thanks for your time, go home, you don't get to deliberate, was viewed as a waste of civic resources.
So what happens if someone gets sick?
Well, now, if you start with 8 jurors and 2 fall terribly ill during week 3, the judge simply dismisses them for good cause. The trial continues with the remaining 6. But 6 is the absolute floor.
Right.
If you drop to 5, you have a mistrial, right? Unless the lawyers explicitly agreed to accept a verdict from a smaller group.
That is the risk. The judge has to weigh how many jurors to seat initially based on the expected length of the trial to provide a buffer against attrition.
Okay, let's pause and do another quick recap. 14 days to demand the jury, 6 to 12 people in the box, and absolutely no alternates.
Spot on.
All right, so we've demanded our jury in time, we've bypassed the waiver trap, and now we actually have 50 local citizens sitting in the wooden pews of the courtroom. The judge is staring at them, the lawyers are staring at them. How do we whittle 50 strangers down to a functioning jury of, say, 8 people?
This brings us to the process of voir dire, which is a French phrase meaning to speak the truth.
Voir dire, okay.
Under Rule 47, the judge, and frequently the lawyers, depending on the judge's specific practices, will ask the potential jurors a series of questions.
Like a job interview.
Exactly like an interview. The goal is to uncover biases.
Oh.
Lawyers use 2 distinct types of challenges to remove people from the jury pool. Challenges for cause and peremptory challenges.
Okay, let's start with challenges for cause. That requires a lawyer to articulate a specific, legally valid reason why this particular citizen cannot be fair and impartial. Right.
Yes.
So let's go back to my rotting tree hypothetical. If I'm suing my neighbor, and it turns out one of the potential jurors in the room is my neighbor's brother-in-law, that is a glaring conflict of interest.
That is a textbook challenge for cause. Other examples include a juror having a financial stake in the outcome of the case, or a juror who openly admits during questioning that they think all lawsuits are frivolous and they would never award money to anyone no matter the evidence. If a lawyer can demonstrate this actual or implied bias, they ask the judge to strike the juror for cause.
And there is no limit on these, right? Like if 20 people in the room all work for the defendant's company, I can strike all 20 for cause.
There is no numerical limit. The only hurdle is convincing the judge that the bias is real.
Which might be hard, right? People don't always admit their biases.
Exactly. Proving actual bias is really difficult. Jurors often give socially acceptable answers. They might say, oh, sure, I can be fair, even if their body language screams otherwise.
Right.
This is why the system provides a second tool, the peremptory challenge.
Ah, the free kick.
Yes, the free kick. In a federal civil trial, each side is given 3 peremptory challenges.
Just 3?
Just 3.
Yeah.
But you do not have to explain yourself. You do not have to prove bias. You simply look at a juror, decide you don't like the vibe they're giving off, and you use one of your 3 strikes to send them home.
So I can strike someone because they frowned at my client?
Yep.
Or because they seemed bored during the questioning?
Absolutely, for virtually any subjective reason. But, and this is a massive but, there is a constitutional boundary line here.
Okay, what's the line?
The Supreme Court has ruled that lawyers absolutely cannot use peremptory challenges to exclude jurors based on race or gender.
Okay, let's dig into the constitutional mechanics of that for a second. The Constitution usually restricts the government, right? Not private individuals.
Right, the state action doctrine.
Yeah, so if I am a private citizen suing a private corporation and my private lawyer is picking the jury, How does the Equal Protection Clause of the 14th Amendment even apply to my lawyer's choices?
That is the exact tension the Supreme Court wrestled with in cases like Edmondson v. Leesville Concrete Co. and GEB, Alabama.
Okay, so how did they resolve it?
The court reasoned that a jury is a quintessential governmental body. The courtroom is a government facility. The judge enforcing the strikes is a government official.
Oh, I see.
Yeah. When a private lawyer exercises a peremptory challenge, they are briefly wielding the coercive power of the state to dictate who gets to participate in a democratic institution. Because they are using state power, they are bound by the Constitution's prohibition against discrimination.
Wow, that makes perfect sense. So if my lawyer uses all 3 of their free kicks to remove 3 women from the jury, the defense attorney is going to stand up and raise an objection.
Yes, what is called a Batson challenge, named after a criminal case, but applied to civil trials as well. The defense will accuse your lawyer of gender discrimination.
And what happens at that moment?
At that moment, the burden shifts. Your lawyer can no longer rely on the free kick nature of the peremptory challenge.
They have to explain themselves.
Exactly. They must articulate a specific gender-neutral reason for why they struck those 3 individuals. They have to say, I struck Juror 4, not because she is a woman, but because she works in the insurance industry and might be biased against plaintiffs.
And then the judge decides if that's legit or just an excuse.
Right. The judge decides if that reason is genuine or just a pretext for discrimination.
It's a fascinating intersection of private strategy and constitutional rights. All right, quick recap on jury selection. Unlimited challenges for cause if you can prove bias. 3 peremptory challenges per side, no reason needed unless it's based on race or gender.
Got it.
Okay, let's fast forward. We have navigated voir dire, we have our jury seated, opening statements happen, witnesses are cross-examined, documents are entered into evidence, the trial concludes.
The fun part is over.
Right. But before the jury is sent to a back room to deliberate, the judge has to give them the instruction manual for the law. This is governed by Rule 51.
Right, jury instructions. These are critical because a jury is composed of lay people. They don't know the elements of common law fraud or the standard for comparative negligence.
I barely know the standard for comparative negligence.
Exactly. So the judge must read them a set of instructions defining the law. They must apply to the facts. And the lawyers will submit proposed instructions, arguing over every single word.
Of course they do. The plaintiff wants the definition of negligence to sound as broad as possible, and the defendant wants to sound impossibly narrow.
Yep. But the judge makes the final call.
But what happens if the judge gets it wrong? Let's say the judge decides to read an instruction that fundamentally misstates the law, making it way too hard for my client to win. What must a lawyer do to protect their case?
The lawyer must object. But the substance of the objection is only half the battle. The timing is everything.
Timing is everything. Why?
Under Rule 51, a party must object to the jury instructions before the instructions are delivered to the jury and before closing arguments. And they must do it on the record, stating distinctly the matter objected to and the grounds for the objection.
Okay, if a student is taking an exam, the word before should be glowing in neon lights. Before the jury hears it. Why is the system so incredibly rigid about this?
It comes down to judicial efficiency and the concept of preserving error. The trial court must be given a fair opportunity to fix its own mistakes.
Okay, so no ambushes.
Right. Imagine if a lawyer sits silently while the judge reads a flawed instruction, lets the jury deliberate for 3 days, lets a verdict come back against them, and then says, hey, judge, that instruction you read on Tuesday was legally incorrect. We need a whole new trial.
The judge would be furious.
Beyond furious. The lawyer essentially hid in the weeds, hoping for a good verdict, but keeping a secret weapon in their pocket to demand a do-over if they lost.
That's sneaky. So the rule prevents that.
It does. If you object before the jury is instructed, the judge can look at the case law, realize their mistake, and fix the language in 5 minutes. If you wait until after the verdict, the only remedy is to throw out weeks of work and start a new trial from scratch.
Got it. So if you fail to object timely, you waive your right to appeal that bad instruction, barring a rare plain error exception.
Exactly. Always object before.
Awesome. Let's do another quick recap. Object to instructions before the jury hears them. Pretty simple, but incredibly important.
Very important.
So the instructions are finalized, the judge reads them, and the jury is sent into the deliberation room. The door locks. This is a black box. The legal system reveres the privacy of jury deliberations.
It really does. It's sacred.
But what if the process inside that room is corrupted? This brings us to the thorny issue of juror misconduct, and the rules are surprisingly nuanced about what kinds of misconduct actually matter.
Let's start with misconduct that might have occurred before the trial even began during that voir dire process.
Yeah.
Suppose a juror lied during questioning.
Okay, like what?
Well, the Supreme Court addressed this in McDonough Power Equip v. Greenwood. Let's say a potential juror is asked, have you or anyone in your immediate family ever suffered a severe injury from a piece of heavy machinery?
Okay.
The juror remains silent, indicating no, but in reality, their son lost a finger in a lawnmower accident a year ago.
Yikes. So the juror clearly lied by omission. When the losing side finds out about this after the trial, they will scream for a new trial, arguing the jury was tainted by a liar.
Naturally. But a lie alone is not enough to overturn a verdict. The McDonough test establishes a rigorous two-pronged standard. First, you must prove that the juror failed to answer honestly a material question on the voir dire. It has to be an important question, not just a trivial misunderstanding.
Well, in this case, asking about machinery accidents in a product liability trial over a lawnmower is highly material, so prong one is met.
Yes, but the second prong is the real hurdle. You must also demonstrate that a correct response would have provided a valid basis for a challenge for cause.
Meaning, the lie had to cover up an actual disqualifying bias.
Exactly.
If the juror lied because they were simply embarrassed to talk about their son's injury in public, but they harbor no ill will toward the manufacturer and could have been completely fair, the verdict stands.
Precisely. The system heavily favors the finality of judgments. A trial is a massive expenditure of public and private resources. The courts will not invalidate a verdict simply because a juror was imperfect or hid an embarrassing fact, unless that fact proves they were legally unfit to serve in the first place.
Okay, that deals with pre-trial lies. But what about the actual deliberations? The jurors are sitting around the table arguing over the evidence. The rule states they must base their decisions solely on the evidence formally admitted in court.
That's the ideal, yes.
But human beings are flawed. What happens when a juror comes forward after the trial and admits things went completely off the rails?
This is governed by Federal Rule of Evidence 606B, which creates a near impenetrable shield around the internal thoughts and discussions of the jury.
How strong of a shield?
Very strong. The general rule is that a juror may not testify to impeach their own verdict. They cannot sign an affidavit saying, we rushed the decisions because we wanted to get to a baseball game, or we completely misunderstood the judge's instructions on the burden of proof.
Or what if they say, we messed up the math when calculating the damages? Wait. If a juror literally signs a sworn statement saying, we intended to award $50,000, but we moved a decimal point and accidentally awarded $500,000, the court will refuse to listen to that.
Generally, yes.
The defendant just has to pay an extra $450,000 because of a clerical math error.
It seems incredibly harsh, but yes. The mental processes, the negotiations, the compromises, and the internal misunderstandings of the jury are strictly off-limits.
Why protect a mistake like that?
Because if lawyers were allowed to interrogate jurors after every trial about their math skills or their reading comprehension, the losing side would harass the jurors endlessly. No verdict would ever be final. The jury room would lose its sanctity, and citizens would be terrified to serve.
Okay, so internal dysfunction is protected. But there has to be a limit, right? What if the dysfunction comes from the outside?
That is the exact exception built into Rule 606B. A juror can testify about whether extraneous prejudicial information was improperly brought to the jury's attention, or whether an outside influence was improperly brought to bear on any juror.
Let's draw that line clearly. If a juror argues in the deliberation room that the plaintiff's math is wrong because the juror happens to be an accountant, that is internal, right?
Yes. They are using their own life experience. That's allowed.
But what if a juror goes to the bathroom, pulls out their smartphone, Googles the defendant's corporate history, finds an article about a past lawsuit, and brings that information back into the room to convince the others?
Now that crosses the line from internal thought process to extraneous information.
Because it wasn't presented in court.
Exactly. The entire premise of a trial is that evidence must be presented in open court so it can be cross-examined and challenged. A juror conducting independent research on Google introduces untested, uncross-examined evidence into the black box.
And that violates fundamental fairness.
It does. If a juror testifies that outside research occurred, the court will investigate and likely order a new trial.
So internal incompetence is shielded, external interference is exposed. No Googling allowed.
No Googling.
All right, let's step back and summarize the operational takeaways for anyone studying this timeline. ESL listeners, this is for you. You secure the jury by demanding it in 14 days. You weed out biases using unlimited challenges for cause, and you sculpt the jury using 3 peremptory strikes. Provided you don't violate equal protection on race or gender, you guard the instructions by objecting before they are read, and you only get to attack the jury's conduct if they lied about a disqualifying bias or brought a smartphone's worth of outside research into the room.
That neatly encapsulates the journey to the verdict.
Awesome. And the verdict itself is our next destination. When the jury finally knocks on the door and says they have reached a decision, what exactly are they handing to the judge?
Well, the federal rules demand unanimity unless the parties stipulate otherwise.
Right.
All 6 or 8 or 12 jurors must agree. But they don't always just hand over a piece of paper that says plaintiff wins. Under Rule 49, there are different architectural structures for a verdict: general, special, and general, with specific interrogatories.
Let's break those down. What is a general verdict?
A general verdict is the standard model. It is a bottom-line conclusion. The jury simply states which party prevails and, if applicable, the amount of damages.
So we find for the plaintiff and award $250,000.
Exactly. It gives no insight into how the jury reached that number or which witnesses they believed.
Which is fine for a straightforward car crash.
Sure.
But what if the case is a sprawling patent infringement lawsuit involving 4 different patents, questions of prior art, complex licensing agreements, and counterclaims? A general verdict would be useless on appeal because no one would know how the jury resolved the underlying technical disputes.
You nailed it. For those complex cases, the judge will utilize a special verdict.
And how does that work?
Instead of asking who wins, the judge gives the jury a highly detailed questionnaire. Did patent A expire before 2020? Yes or no. Did the defendant's product utilize the mechanism described in Claim 3? Yes or no.
So the jury acts purely as a fact-finding machine.
Right. They answer the specific questions, and then the judge takes those answers, applies the law, and formally declares who wins.
I use a math test analogy to keep these straight. ESL learners, if you need a visual, here it is.
Oh, what's yours?
A general verdict is the teacher giving you a complex algebra equation and just letting you write the final number at the very bottom of the page. You either get it right or wrong, but the teacher doesn't know your thought process.
Right.
A special verdict is the teacher refusing to let you give a final answer and instead grading you strictly on whether you can show your work on every single step of the equation.
That's a perfect analogy.
Yeah.
And the third type, the general verdict with interrogatories, is a hybrid.
Okay, explain the hybrid. By the way, interrogatories just means questions, right?
Yes, just questions. So in the hybrid, the jury gives the final bottom line answer, who wins and how much. But the judge also forces them to answer a few critical, factual questions along the way to ensure their logic tracks.
What happens if their logic doesn't track? Like, if the jury's answers to the interrogatories contradict their general verdict. For example, if they find the defendant was not negligent, but still award the plaintiff money.
Well, then the judge has a problem to sort out. The judge can send them back to deliberate more, or order a new trial.
Messy.
Very.
So once that verdict is read aloud in court, the losing lawyer isn't entirely out of options to stop it from becoming final. There is a dramatic procedural move called polling the jury under Rule 48C?
Yes, polling the jury. The lawyer can demand that the judge ask each individual juror in open court to confirm the verdict.
Like, juror number 1, is this your verdict? Juror number 2, is this your verdict?
Exactly. It seems theatrical, but it serves a vital psychological purpose. Deliberations can be intense. Group dynamics can turn toxic. You might have 5 dominant personalities who verbally browbeat a dissenting juror until they finally cave in just so everyone can go home.
They surrender inside the locker room.
Right. But out in the courtroom, standing under the lights, with the judge looking directly at them, the pressure dynamic shifts.
Polling gives that bullied juror one last safe opportunity to say, "No, Your Honor, I was pressured. I do not agree with this."
And if that happens, the unanimity is broken. The judge will either order the jury to return to the deliberation room to keep trying, or declare a mistrial and discharge them entirely.
Wow. Okay, let's recap verdicts. General is bottom line. Special is showing your work. General with interrogatories is a mix, and polling the jury makes sure everyone actually agrees.
Perfect.
Now, what if we never had a jury in the first place? We mentioned earlier that if you fail to demand a jury, or if you are solely seeking an equitable injunction, The judge tries the case alone. This is a bench trial governed by Rule 52A.
Right. In a bench trial, the judge absorbs both roles. They are the referee managing the law and the jury weighing the facts. But because there is no jury to hide behind a simple general verdict, the judge's burden of transparency is much higher.
The judge can't just bang the gavel and say, "I've listened to the evidence, the plaintiff wins."
No, they can't. Rule 52A requires the judge to find the facts specially and state his conclusions of law separately.
What does that look like in practice?
The judge must draft a document or dictate onto the record a clear sequential path of logic. I find, as a matter of fact, that the light was red. I find, as a matter of fact, that the defendant was speeding. Therefore, I conclude, as a matter of law, that the defendant breached their duty of care.
Why is that separation so crucial?
It's crucial for the appellate courts. If the judge gets the facts wrong, the appellate court is very deferential. They usually trust the trial judge's view of the witnesses. But if the judge applies the wrong law to those facts, the appellate court will reverse it immediately. They need to see the math.
Got it. Now, before we move completely into the post-trial phase, there is a mechanism mentioned in the materials that operates parallel to the trial itself. It is a protective measure called prejudgment attachment found in Rule 64.
Ah, yes. This rule acknowledges a harsh reality of litigation.
Which is?
Winning a judgment is merely getting a piece of paper that says someone owes you money. Collecting that money is an entirely different battle.
The fear of the empty victory. Imagine you're suing a known corporate fraudster. The evidence is overwhelming. You are going to win a $5 million verdict next month. But you know for a fact that the fraudster is currently liquidating their assets, selling their real estate, and wiring the cash to an offshore account in a jurisdiction that won't enforce American judgments.
A nightmare scenario.
Right. By the time the jury hands you that victory, the defendant's bank accounts will have a zero balance.
That scenario is exactly why prejudgment attachment exists. It allows a plaintiff to ask the court to seize or freeze the defendant's property before the trial is even finished.
You're essentially putting a lock on their assets to ensure that if you win, there's actually a pot of money waiting to satisfy the judgment. It's like putting a hold on someone's wallet so they don't run away.
That's a great way to put it.
But seizing someone's bank account before they have been found liable by a jury feels like a massive infringement on due process. You are punishing them before they lose.
Which is why the procedural hurdles are immense. You can't just do this on a whim. First, Rule 64 relies on the law of the state where the federal court is located, so the specific mechanisms vary. But generally, the plaintiff must make a compelling preliminary showing.
Showing what?
They must demonstrate a high likelihood of success on the merits. You can't just freeze someone's assets on a weak claim. You have to show the judge that your case is so strong, a victory is almost inevitable, and that the risk of the defendant dissipating assets is real and imminent.
And isn't there usually a bond involved?
Yes. Often, the plaintiff must post a bond, a chunk of their own money, to compensate the defendant just in case the plaintiff ends up losing the trial and the freeze was unjustified.
It's an aggressive preemptive strike. Okay, let's do a quick recap. Verdicts must be unanimous by at least 6 people. Special verdicts ask specific questions. If it's a bench trial, the judge has to write out the facts and the law separately. And prejudgment attachment is freezing the wallet so they don't hide the money.
Excellent summary.
So, whether by a jury's general verdict, a special verdict with interrogatories, or a judge's findings of fact in a bench trial, we have reached the end of the evidence. And this brings us to the most heavily tested, most fiercely debated area of civil procedure.
Oh boy. Here we go.
What happens when the legal system decides the jury is simply wrong? What happens when the referee blows the whistle and takes the game away from the players?
We are talking about judgment as a matter of law, commonly referred to as JOL, governed by Rule 50.
JMOL. JMO.
Yes. Older practitioners and many state courts still use the term directed verdict, or JNOV, but the federal concept remains the same. JMOL is the ultimate safety valve against irrational juries or hopelessly weak cases.
Let's trace the mechanics. JMOL happens in 2 distinct phases. Rule 50A happens during the trial, before the jury deliberates. Rule 50B happens after the trial, once the jury has delivered a verdict. Let's start with 50A.
Under Rule 50A, a party can move for JMOL at any point after the opposing party has been fully heard on an issue, but before the case is submitted to the jury.
Let's use an example.
Okay, imagine a scenario where you are defending a medical malpractice lawsuit. The plaintiff presents their entire case, calls all their witnesses, and rests. But for some inexplicable reason, the plaintiff never called a medical expert to establish what the standard of care actually was.
They missed a foundational element of the claim. They proved an injury occurred, but they didn't prove the doctor deviated from accepted medical practice.
Exactly. At that moment, as the defense attorney, you stand up and say, Your Honor, I move for judgment as a matter of law.
And what standard does the judge apply?
The standard is strict but clear. The judge must determine if a reasonable jury would have a legally sufficient evidentiary basis to find for the plaintiff on that issue.
And because medical malpractice requires expert testimony as a matter of law and none was presented,
A reasonable jury cannot legally find for the plaintiff.
there is literally nothing for the jury to debate.
Precisely. The judge grants the motion, essentially saying, we don't need the jury's opinion here. The law dictates that the defendant wins because the plaintiff's evidence is legally non-existent. The trial ends right there.
But the judge has to be incredibly careful not to overstep. If there's any evidence, things get complicated. The Supreme Court laid out the rules of engagement for judges in Reeves v. Sanderson Plumbing Prods, Inc.
Yes, the Reeves standard.
When a judge is deciding a JMOL motion, how must they view the evidence?
The Reeves standard requires the court to view all the evidence in the light most favorable to the non-moving party. And the absolute golden rule, the one that trips up law students constantly, is that the judge cannot make credibility determinations or weigh the evidence.
Okay, let me push back with a hypothetical to test that boundary.
Bring it on.
I am the plaintiff. I claim the defendant ran a red light and hit me. The defendant moves for JMOL. The defendant has dash cam video showing the light was green. They have 3 nuns who testify the light was green.
Nuns. That's tough evidence to beat.
Right. I have 0 video, but I take the stand and testify I swear the light was red. The defense attorney says, Judge, her testimony is absurd. The video proves she is lying. Grant JMOL. Can the judge grant it?
No. The judge must deny the JMOL.
Wait, really? Even if the judge knows I am lying because the video clearly shows a green light?
Yes. Because if the judge grants JMOL based on the belief that the video is more reliable than your live testimony, the judge is weighing evidence and making a credibility determination.
And that's not allowed.
It's not allowed. In the American legal system, assessing credibility is the exclusive sacred domain of the jury. If the judge views the evidence in the light most favorable to the non-moving party, which is you, the plaintiff, the judge has to accept your testimony as theoretically true for the purpose of the motion. Because your testimony creates a factual dispute, the case must go to the jury to let them decide who is telling the truth. JMOL is only for situations where there is a complete absence of evidence, not merely weak or contradicted evidence.
That is a brilliant line to draw. The judge evaluates the existence of evidence, not the quality or believability of it. If there's evidence, let the jury sort it out.
Exactly. Now, there is a procedural quirk mentioned in the materials regarding when a lawyer actually makes this 50A motion. It involves a circuit split among the federal appellate courts.
Briefly, what is that split?
Well, let's say the defendant makes a 50A motion right after the plaintiff rests their case. The judge denies it. The defendant then puts on their own witnesses and rests their case. The question is, does the defendant have to stand up and make the exact same 50A motion a second time at the close of all evidence to preserve their rights?
And the courts disagree.
Yes. The Seventh Circuit Court of Appeals is highly formalistic. They say, yes, you absolutely must renew the motion at the close of all evidence. But the Eighth Circuit takes a more relaxed approach, saying the first motion was sufficient.
So for anyone taking a national exam, you don't necessarily need to pick a side, but you need to recognize that the timing of the 50A motion is a heavily litigated trap.
And that trap sets the stage for the most dangerous pitfall in all of civil procedure. Rule 50B.
Rule 50B. The renewed motion for judgment as a matter of law. This is the post-trial phase. The judge denied your 50A motion during the trial. The case went to the jury, and the jury went completely rogue.
That happened.
They ignored the law, they ignored the lack of evidence, and they handed down a verdict against you. You are furious. The trial is over, judgment is entered. You have 28 days to file a Rule 50B motion, begging the judge to override the jury's verdict and enter judgment for you instead.
28 days is the deadline. But the prerequisite for filing this motion is where lawyers lose their malpractice insurance.
Oh boy.
You absolutely cannot file a Rule 50B motion after the trial if you did not properly file a Rule 50A motion during the trial before the jury began deliberating.
Okay, I use an analogy here that I think cuts through the legal jargon perfectly. I want everyone to remember this.
Go for it.
Think of the 50A motion, the one you make during the trial, as a receipt from a store. And think of the 50B motion, the one you make after the trial, as asking for a refund.
That is an incredibly apt comparison.
Right. You cannot walk into a store, hand them a broken product, and demand a refund if you cannot produce the receipt showing you bought it there in the first place.
Exactly.
In the courtroom, if you sit silently during the trial, if you let the case go to the jury without standing up and asking for J-Mall under 50A, you never got your receipt. When the jury comes back with a terrible verdict and you try to ask the judge for a 50B refund, the judge will look at you and say, "Where is your 50A receipt? If you don't have it, you are barred. The court cannot grant the motion. You waived the right entirely."
And this isn't just an arbitrary procedural hurdle designed to trap unwary lawyers. There was a profound fairness rationale behind it.
Why? Why force them to do it before?
Well, why do we force a lawyer to make the 50A motion before the case goes to the jury? It operates as a warning system. Let's go back to the medical malpractice example where the plaintiff forgot to call the expert witness.
Okay.
If the defense lawyer stands up and makes a 50A motion, pointing out this fatal flaw, the plaintiff realizes their mistake right then and there.
And the judge, in the interest of justice, might actually say to the plaintiff, "I'll give you a 1-hour recess to get your doctor on the phone and reopen your case to fix this error."
Exactly. The 50A motion gives the opposing party an opportunity to cure the defect while the trial is still happening. If we allowed a defense lawyer to secretly notice the missing evidence, say nothing, let the jury deliberate, and then spring a 50B motion after a bad verdict, it would be an unfair ambush.
That makes total sense. The plaintiff would be permanently defeated over a mistake they could have easily fixed if they had been warned.
Right. The Receiver Fund rule ensures that no one can hide their legal arguments until it's too late. The Supreme Court has enforced this rigidly.
Okay, let's recap this slowly for the note-takers. JML takes the case away from the jury. The judge evaluates if there's any evidence, but doesn't judge who is telling the truth. You have 28 days after the trial to ask for a renewed JML, your 50B refund, but only if you asked for it before the jury started deliberating your 50A receipt.
That is the perfect summary.
Awesome. This transitions us into the final phase of litigation, the end game. Section 5. We have a verdict, we have a judgment, now we have to deal with the fallout. Costs, attorney's fees, settlement gamesmanship, and the final desperate pleas for a new trial.
Let's address the financial fallout first, governed by Rule 54. There is a fundamental distinction in American law between costs and attorney's fees.
Most people think those are the same thing.
You do, but they're very different. Costs refer to the administrative expenses of running a lawsuit. This includes filing fees paid to the clerk, the money paid to court reporters to transcribe depositions, and statutory witness fees. Attorney's fees are the hundreds or thousands of dollars an hour you pay your lawyer to argue the case.
And the allocation of those two buckets of money operates under entirely different rules.
Correct. The default rule for costs is that the prevailing party, the winner of the lawsuit, automatically recovers their costs from the losing party.
Automatically.
Pretty much. You do not even need to file a formal, complex motion. The clerk of the court can tax costs on 14 days' notice. If you win, the loser reimburses you for the court reporter and the filing fees.
But the American rule for attorney's fees is notoriously unforgiving.
Very unforgiving. Under the American rule, every party pays their own lawyer, regardless of who wins or loses. The only exceptions are if a specific federal statute authorizes fee shifting, like in many civil rights cases, or if the parties signed a contract that explicitly states the winner gets their fees paid.
Okay, and if you fall into one of those exceptions?
If you do, Rule 54 dictates that you must file a motion claiming attorney's fees no later than 14 days after the entry of judgment.
14 days. It is a very tight window to submit your billing records to the court. Now, intertwining with this issue of costs is one of the most fascinating manipulative rules in the entire book, the Rule 68 offer of judgment.
Oh, Rule 68.
This rule isn't about fairness. It is a weapon designed to bully parties into settling and clearing the court's docket.
It is a high-stakes tactical maneuver. Rule 68 allows a defending party to serve on the plaintiff an official offer to allow judgment on specified terms. They must do this at least 14 days before the trial begins.
Let's lay out the poker game here.
Let's do it.
I am suing you for a slip and fall. I think my case is worth $100,000. You, the defendant, served me with a Rule 68 offer 14 days before trial. The offer says, I will pay you $30,000 right now to end this. I look at the offer, I laugh at it, and I reject it, deciding to roll the dice at a jury trial.
Okay, so you go to trial. You present your evidence. You win the case. The jury finds me liable for your injuries. But the jury decides your injuries weren't that bad and they only award you $20,000.
Okay, but I still won the lawsuit. I beat you in court. But I won less than the $30,000 you offered me 2 weeks ago. What are the consequences of my gamble?
The consequences are punitive. Even though you are the prevailing party, because you rejected a reasonable offer and dragged the system through a trial that ultimately yielded less than the offer, Rule 68 shifts the financial burden.
Shifts it how?
You, the winning plaintiff, must pay all of the defendant's costs incurred after the offer was made.
Wait. So if you spent $15,000 on expert witness fees and court reporters during the trial, I have to pay that out of my $20,000 verdict?
Exactly. Your victory is completely hollowed out. You won the battle but lost the war because you miscalculated the value of your case.
That is brutal.
Rule 68 forces plaintiffs to take a hard, cold look at settlement offers instead of being blinded by optimism. It intentionally penalizes parties who waste judicial resources on trials that should have been settled.
It is a brilliant, terrifying mechanism. Okay, let's look at the broader post-trial motions. If you lose the trial entirely and you didn't have your Rule 50A receipt to file for JMLL, what else can you do? The materials emphasize a magic number for these final Hail Mary motions: 28 days.
28 days after the entry of judgment is the critical deadline for several major rules. We have Rule 52B, which is a motion to amend or make additional findings in a non-jury bench trial. We have Rule 59E, which is a motion to alter or amend a judgment. And most significantly, we have Rule 59A, the motion for a new trial.
A motion for a new trial is exactly what it sounds like. You are asking the judge to throw the entire verdict in the garbage, wipe the slate clean, and force everyone to start over with a brand new jury.
Right. And the judge has broad discretion to grant a new trial to prevent a miscarriage of justice. However, the system is buffered by Rule 61, the harmless error rule.
What's harmless error?
The court must disregard all errors or defects in the proceeding that do not affect any party's substantial rights.
Which makes sense. I mean, a 2-week trial is a human endeavor. It will never be flawless. A lawyer will ask a leading question. A judge might admit a document slightly out of order. Someone might sneeze during a key testimony. If the error didn't actually change the trajectory of the verdict, the judge isn't going to order a multi-million-dollar do-over.
Right. But there are specific grounds that do justify a new trial. Prejudicial misconduct by a lawyer, the judge, or a juror, like our Googling juror earlier. A verdict based on false evidence or newly discovered evidence.
Let's clarify, newly discovered evidence. This doesn't mean something that just happened yesterday. Right?
Correct. To get a new trial based on newly discovered evidence, that evidence must have actually existed at the time of the trial. Furthermore, the party must show that they were excusably ignorant of the evidence despite using due diligence to find it, and that the evidence is so significant it would likely change the outcome of the trial.
So you cannot get a new trial simply because a witness changed their mind a month later or because a new scientific study was published after the verdict.
Exactly. It had to exist during the trial, but you just couldn't find it.
Got it. The final 2 grounds for a new trial are the most conceptually difficult and the most heavily tested on the bar exam. When the verdict is against the clear weight of the evidence and when the jury's damage award is shockingly excessive or inadequate.
This brings us to the dual concepts of remititure and additure. These involve the judge intervening not because the jury got the liability wrong, but because the jury lost their minds when calculating the money.
Okay, let's explore remititure first. Remit essentially means to reduce. Let's use a hyperbolic example based on famous cases. A plaintiff sues a fast food company because they slipped on a wet floor and sprained their wrist. The jury finds the company liable. But the jury hates the corporation so much that they award the plaintiff $50 million for a minor sprain.
That verdict is grossly excessive. It shocks the judicial conscience. The defendant will file a Rule 59 motion for a new trial. The judge agrees the number is absurd. But instead of forcing everyone to do the entire trial over again just to get a more reasonable number, the judge can utilize remititure.
But the judge cannot just cross out the $50 million on the verdict form, write in $50,000, and enter judgment right.
No, the judge cannot unilaterally change the number. The judge uses a conditional order.
How does that sound?
The judge says to the plaintiff, I am going to grant the defendant's motion and order a completely new trial because this verdict is legally excessive unless you agree to remit or give up a portion of the damages and accept a reduced award of $50,000.
So the plaintiff has a choice: accept the drastic pay cut or risk walking away with $0 at a second trial. It is a powerful tool to enforce rationality. Now let's flip the scenario. What about additure?
Additure.
The plaintiff is in a catastrophic car crash caused by a drunk driver. The plaintiff loses both legs. The medical bills alone are $2 million. The jury finds the drunk driver liable, but for some inexplicable, malicious reason, the jury awards the plaintiff $1 single in total damages.
The verdict is undeniably, shockingly inadequate. It contradicts the undisputed evidence of the medical bills, so the plaintiff moves for a new trial.
Right. Can the judge use additor? Can the judge look at the defendant and say, I am granting a new trial unless you agree to add to the verdict and pay the plaintiff $2 million?
This is a trap that snares thousands of law students. The answer is absolutely unequivocally no.
No.
Additor is strictly prohibited in federal courts. The judge's only remedy when a verdict is too low is to order a new trial.
I need to push back on this. This seems incredibly hypocritical. Why is remittitor reducing a crazy high verdict perfectly acceptable, but additor adding money to a crazy low verdict illegal? There are just two sides of the exact same coin, aren't they? The judge is manipulating the number to achieve fairness in both cases.
They appear identical in function, but they are constitutionally opposed. It all traces back to where we started this deep dive, the Seventh Amendment guarantee of a trial by jury.
Okay, walk me through the logic.
With remittitor, when a jury awards $50 million, they have implicitly agreed to award $50,000, plus a lot more.
Right.
The jury authorized every single dollar from $0 up to $50 million. When the judge offers a remittitor down to $50,000, the judge is simply trimming the excess fat. The final $50,000 judgment is a sum of money that the jury actually authorized.
Okay, I see the logic there. The judge is just keeping a smaller slice of a pie the jury already baked.
Exactly.
Right.
But consider additor. If the jury awards $1 single, they have explicitly refused to authorize $2, or $1,000, or $2 million. If the judge tries to force the defendant to pay $2 million, the judge is inventing $1,999,999 that no jury ever agreed to.
The judge is cooking an entirely new meal that the jury never ordered.
Precisely. Forcing a defendant in a federal civil trial to pay a judgment amount that was never authorized by a jury of their peers is a direct, fatal violation of the Seventh Amendment. The Supreme Court established this asymmetry in 1935 in Democrat, and it remains binding federal law today. State courts often allow additor under their own state constitutions, but in federal court, it is constitutionally forbidden.
That is a brilliant constitutional distinction. Remittitor trims the fat, additor cooks a new meal. I love that. Okay, final rapid-fire recap of deadlines. 14 days for attorney fees, 14 days for a Rule 68 offer, 28 days for almost all post-trial motions, JMOL, new trial, amending judgments. Remittitor reducing money is okay. Additor adding money is never okay in federal court.
You've got it down perfectly.
If we take a breath and survey the landscape we have covered, we have traced the entire arc of civil procedure. We started by following the money to secure the Seventh Amendment right, demanded it within 14 days, struck biased jurors for cause, and navigated peremptory challenges without violating equal protection. We objected to bad law before the jury heard it, protected the jury's internal math errors, but banned their outside Googling. We saw judges take the case away with JMOL, provided we kept our 50A receipt to get our 50B refund. We navigated the 14-day poker game of Rule 68 costs, hit the 28-day deadline for post-trial motions, and finally crashed into the constitutional wall separating remittitor from additor.
It's a lot, but when you synthesize all of these disparate, highly technical rules, what emerges is not just a dry manual of deadlines. The federal rules of civil procedure are fundamentally an intricate architecture designed to balance power.
It is a constant tug of war.
It really is. The rules are designed to balance the power between ordinary citizens, the jury, and the legal expertise of the system, the judge. Every deadline, every requirement for a written motion, every restriction on what a judge can and cannot do with the evidence exists to ensure that neither side of that equation becomes tyrannical.
Right.
The jury provides the democratic voice and community standards, while the judge provides the guardrails of the law and prevents total chaos.
It is a remarkable system. But I want to leave everyone listening with a final, slightly provocative thought to chew on as you study these concepts. We started by talking about the referee in a game and how jarring it is when the referee steps in to redefine the score.
Yeah.
We spent this time discussing how a judge can use JMOL to declare that no reasonable jury could decide a certain way, or use remittitor to declare that a jury's damage award shocks the conscience. But if the Seventh Amendment guarantees a trial by a jury of our peers who actually decides what is reasonable or whose conscience is being shocked, the rules present the judge as a neutral, objective referee applying scientific legal standards. but a judge is just a human being in a robe.
That's very true.
When a judge decides that 6 citizens in a jury room are being unreasonable, isn't the judge ultimately just substituting their own personal human judgment for the collective judgment of the community? Isn't it fascinating how much power the referee has to redefine the rules of the game right at the finish line, simply by labeling the players unreasonable?
That is a fantastic point to end on. It really makes you think about the human element in all of these rigid rules.
Think about that inherent tension the next time you read a Supreme Court opinion on civil procedure. Thank you for joining us on this deep dive. Keep unpacking those rules, keep pushing through the dense jargon, and keep mastering the law one step at a time. We will see you next time.